All righty, we are going to go ahead and get started. Good afternoon, everyone. Thank you so much for joining us. This is ICRC's second live virtual event focused on COVID-19. My name is Mackenzie Holden. I am going to be serving as the moderator. I am the communications manager at the ICRC. Today's presentation, we're focusing on COVID-19 and employment, and we're going to be listing some resources available to you guys as Hoosiers. And our two presenters today are Keisha Greene, Director of Employment here at the Indiana Civil Rights Commission, as well as Brian Shoemaker, Education and Outreach Coordinator with EEOC. Both presenters are going to discuss COVID-19 in the workplace, and they're going to be passing along some great resources and guidelines available for all Hoosiers as Indiana gets back on track. Before I begin, I want to go ahead and mention that this entire presentation is going to be recorded and uploaded onto our website at in.gov/ICRC. Tomorrow morning, you should be able to access both the video and the presentation, as well as all of the questions and answers from the presentation. And during the presentation, we ask that if you do have any questions or concerns, on the right side of your screen, you will see a little icon with two little comment boxes with a question mark on that. And if you click that icon, it'll pop up your Q&A box, and you will be able to type any questions you have throughout the presentation. I'm going to do my best to monitor the Q&A box throughout the entire presentation and answer as many questions as we can. But if your question does not get answered right away, we are going to address all of the questions at the very end in a Q&A session. So in order to use that Q&A, it will ask for your name on the first line and the second lines where you're going to type out your question. If you want to have it presented as anonymous, you just click the box for anonymous. So thank you again for joining us, and I'm going to go ahead and pass it on to Keisha Greene, Director of Employment at ICRC.
Hello, everyone. My apologies. You can't get more COVID era than that. Again, as Mackenzie mentioned, my name is Keisha Greene. I am the Program Director for the Employment section of the Indiana Civil Rights Commission. I am here today to share with Brian Shoemaker, who is from the EEOC, and we will be giving you information on a COVID era workplace. And we're starting out by being definitely reflective of that workplace by doing this webinar. Again, you can't get more COVID era than this. So I would like to start. Biggest takeaway that I would like you all to remember is that pandemics are not permanent. If there's anything that you take with you today, it's that pandemics are not permanent. And much of what we share today about COVID will not be permanent as well. So it is a novel virus. Things are ever evolving. The government's response, employers, and what they can do in the workplace. So just be aware that what we're here to do is share information. And I have a disclaimer that I'd like to share and read word for word with each of you. So that disclaimer should be popping up. I'd like to first start by saying that no information contained in or discussed pursuant to this presentation may be considered legal advice. If you require legal advice or guidance, please contact an attorney. The information contained in this presentation is only intended to provide general information and not to be interpreted as Indiana Civil Rights Commission or Equal Employment Opportunity Commission's policies. We are simply sharing information, and we're glad to share it. Moving on to the next slide, I'd like to share what the purpose of our commission is. The Indiana Civil Rights Commission enforces the civil rights laws of the state of Indiana. We investigate complaints of discrimination and educate organizations and individuals such as yourselves about your responsibilities and individuals' rights under the Indiana civil rights laws. Now, we have several enforcement areas. Those enforcement areas include employment, and that's our focus for today, but we also cover real estate, public accommodation, credit, and education. So all of those are our enforcement areas, and we investigate complaints related to discrimination in those areas. Moving on to our protected classes, in Indiana, a person may not be treated differently, and I would qualify and say may not be treated less favorably because of their membership in certain classes, including race, based on their race, color, gender, veteran status, national origin, ancestry, religion, and disability. Our two largest classes, as far as claims, have always been race and disability. And I would argue that that trend is likely to continue given their correlation with COVID issues. So who is covered under our laws in the state of Indiana? Any person, and I use that word operatively because corporations are considered persons. So any person or employer that has at least 6 or more persons within the state. So our jurisdiction is expanded a little bit more than EEOC's because in order for EEOC to have jurisdiction, the entity must have 15 or more individuals that they employ. An employee is not included if they are, or we don't have jurisdiction if this person is employed by a parent, a spouse, or in the domestic service of any other person. So those individuals are excluded from our statute. So this is the takeaway here, what's covered on this slide. Brian is here to discuss issues of particular importance. If we look at the first bullet point, we are here to discuss employment decisions based on stereotypes or assumptions. Assumptions about the origin of the virus are prevalent, and in response to that, there have been many visceral reactions to certain groups of people, and Brian will share a bit about that. Harassment on the basis of membership in a protected class. EEOC has been actively educating us on civil workplaces. And I would argue to say that in this day and age, in the COVID era, we need to rise a little bit above just being civil, but also being empathetic, because everyone is facing some type of stress level, right? I would say at least 80% of you on this presentation have faced stress levels that are very more of an anomaly, which you've not experienced before, because we are experiencing novel issues. And I'll give you an example of what I experienced on yesterday. So my stress level was at a 10. I discovered right before I was supposed to go on and practice with Mackenzie for this presentation that I needed to print, and it was a large print job. So I sent that print job over to my office. I'm working remotely, and there were several pages, and for some reason, not only was I delayed in getting on my call with Mackenzie because of this print job, but the print job did not go through right away. So that was a bit frustrating for me, right? I had received a few emails, and I was receiving emails while I was on the call or the video conference with Mackenzie. And I was in a panic because the person on the other end said that the print job, for the most part, did not go through. It took me about 45 minutes to carry that practice out, so I really didn't want to repeat it. And so it was stressful to focus on my video conference as well as deal with that issue. So to add to that layer, while I was on the phone or on that video conference, my manager calls and he says, SPD or state personnel needs this information right away. So I have these 3 things coming at me at once, right? Which was pretty stressful. And I couldn't figure something out on the video conference, which my husband was supposed to help me with, but he was on his own video conference. Again, these are issues that are novel to us because these are COVID era issues, but they're also 21st century problems, right? They're 21st white collar problems. So I had a teenager who was not happy with anything I was doing yesterday, and she expressed it very clearly. So all of these things were coming at me, and what I wanted to do was to close this laptop and say I'm done. But that wasn't an option, right? So what we probably can't see from home when we're distantly working or engaging is that people have things happening and they're not as intuitive, or we wouldn't be as intuitive to those issues when we're working remotely. So again, that's a white collar problem, but imagine the individual who's had their hours cut. They had their hours cut, they're a single parent, and they may have an underlying health condition. Again, another level of stress. So not only do we need to focus on being a civil workplace, which Brian will share about, but also being an empathetic one. And employers also will need to focus on reasonable accommodations and being in compliance with the ADA, or the Americans with Disabilities Act. The reality is there are a disproportionate number of individuals that belong to a certain racial category who have underlying conditions that impact them greatly. And I happen to be a part of that membership. And we definitely need employers to engage in that interactive process and to really listen to what those individuals' needs are. And also, employers have to be mindful of retaliatory conduct. Now, one particular company that comes to mind is a major warehouse that we have throughout this country that provides us all with products. And you may have heard that there were some safety issues that workers that tried to grieve as employees of that employer. Of course, that doesn't apply to our office because their retaliatory conduct or the firing of those individuals did not result from their membership in a protected class. But it is an issue that's definitely prevalent in this day and age, in the COVID age. So all of these are different types of issues that Brian will address in the rest of this presentation. I will be back at the end, and I will pass it along to Brian Shoemaker without further ado.
Thank you very much. And let me share my screen here real quick. All right. Okay, so what I'd like to talk today about is the EEOC and COVID-19. My name is Brian Shoemaker, and I'm the Outreach and Education Coordinator for the Equal Employment Opportunity Commission. And we're going to talk today a little bit about COVID-19, how it affects the EEOC and some of the laws that the EEOC enforces. And kind of a spoiler alert, it doesn't really affect it too much. Okay, so that's kind of the upside. But we are going to talk a little bit about what happens in a pandemic and why things might change when a pandemic occurs with some of the EEOC laws. First off, just to give you an idea of who the EEOC is, the EEOC, we are a federal agency. We're a neutral federal agency. We are a law enforcement agency. And what we do is we deal with complaints of employment discrimination. We were created by Congress with the passage of the Civil Rights Act of 1964. We opened our doors in 1965. And we have several offices nationwide. The Indianapolis District Office, which is where I am located, we have all of Indiana, all of Kentucky, all of Michigan, and then half of Ohio, and that's our jurisdiction. One of the ways you can think about the EEOC and some of the laws that we enforce, and Keisha has talked about some of the laws that ICRC enforces, they're very similar in nature. Here are some of the laws, and it's very nice to look at. And I'm kind of going to move through this quickly because Keisha has already talked about most of these already. But you can see these are the laws that we enforce at the EEOC. And it's an interesting way to look at them. But really, what does that mean? What does it really mean to be protected by the Americans with Disabilities Act or the Title VII of the Civil Rights Act? This is a better way to break it down. These are the protected bases that the EEOC looks at. And again, Keisha has already talked about a lot of these already because some of the laws kind of overlap. The one thing that I will point out is that for us, it's unlawful to discriminate in employment federally based on these protected bases. You will see here that age is also included on a federal level. So if you're older than 40, you are protected by the EEOC. One thing you don't see here, because another agency takes care of it, is a veteran status. So veteran status is something that's taken care of by another agency, not the EEOC. But really what I want to talk about today is COVID-19 and some of the information that where you can find information about COVID-19. What are your rights and the current guidelines with Title VII and with the emphasis on national origin. I'm going to talk a little bit about the Americans with Disabilities Act because that's really important, how that kind of interacts with COVID-19 because it's a pandemic right now. And then really just understand that reasonable accommodations are still required under the Americans with Disabilities Act. Nothing has changed in that respect. I'm only going to deal with the EEOC and employment issues based on the EEOC's laws and guidance. So if you have any other information, wage and hour issues, issues on some of the other laws that have come up, the FFCRA, which is the Families First Coronavirus Response Act, that's all DOL. So a great place to find information about that is www.dol.gov. They have tons of information for you, and I would recommend looking at that information as well. The other thing that I would recommend is that you take a look at the EEOC's website on coronavirus. It is outstanding. There is a lot of information regarding the coronavirus on our website, and here's the best part, it is all updated. It's all the updated information. Just this morning, the EEOC posted new information about the coronavirus. So there is even more new information out there. And so, trying to keep up to date with this, the best way to do that is to go to our website. And most of your questions will be answered on the website. And I would highly recommend before you come and kind of ask questions to me about that, which you certainly can do. I'm going to give you my information. You can certainly call me, you can email me. But I think one of the best places to go is first is the EEOC website. It's going to have updated information about what is happening, what your rights are, and how they are affected by the coronavirus. And quite honestly, the what you should know, the frequently asked questions about the ADA and COVID-19 is a great resource. I highly, highly, highly recommend that you check that out. That's going to be the best resource that you can find with the EEOC information. So one thing I kind of first wanted to point out about this is that national origin discrimination is still protected and nothing has changed. It is still an employer's job not to discriminate, and that includes harassment. And so and national origin discrimination includes Asian Americans and other people of Asian descent. And it is unfortunate, but we have seen an uptick in national origin discrimination based on Asian Americans and Asian descent in the EEOC in the past couple of months. And so I want to make sure that people are aware of that. It's still something that is against the law. It's harassment is still a big issue within the EEOC. And this in particular is something that we are really going to be focused on. The EEOC is really going to be focused on national origin discrimination. And so if you're a business owner, if you're an employee, this is something that you should be looking out for as well. So I want to talk about harassment because harassment is kind of changing. We have now a virtual workforce. A lot of people are now have been out of work or they're working from home. And so there's more opportunities for harassment to occur, and we may not know what to do about it, because we haven't seen this type of harassment before. Cyberbullying is still a big issue, and that can lead to legal forms of harassment. And so what the EEOC wants to do is give you some ways to prevent harassment from occurring, especially in this time where we're talking about a virtual reality, a virtual workspace. One of the biggest issues that we see is communication. And miscommunication really is a way that leads to harassment issues and can lead to harassment issues. So with issues of miscommunication, one of the things that we see is emails. Emails are sometimes not the most effective way to communicate with either your employees or with your coworkers. I know that we have all received that email in all caps. and you're wondering, why is this person shouting at me? What did I do? I don't understand the tone of this email. And so sometimes email can really be an issue for trying to understand the intent of that individual. So working in a virtual workspace, a better way to communicate is either through video conference or any method that the employee likes. Maybe an employee would rather have a phone call. That's great too. Have a phone conversation. That's fine. Maybe an employee likes Slack or a coworker likes Slack to communicate another way that maybe is best. But video conferences are really a good way to communicate, especially in this time where you can see the person, you can see their reaction, you can see if they're being sarcastic, or you can tell by face-to-face and read all those cues, those body language cues that are so important in communication. The other issue is address issues right away. So if you're an employer and an employee comes to you and says, I have an issue or problem, it's easy now that we're not working together, right? It's very easy now to say, oh, I'll just deal with that problem tomorrow. I'm not going to see that employee for a while. I'll just deal with that problem tomorrow or the next day or whatever. And soon enough, you've forgotten about that issue. But that issue is still real to that employee. So, the recommendation, the best practice is when you have an issue, especially in a virtual workspace, deal with that issue right away. Employees is the same way. If you have an issue or a problem, it may be easy just to say, well, I'm going to have a telephonic conference with my supervisor in a few weeks. I'll just wait till then. The best practice is to make sure that you're communicating with your supervisor if there's an issue or problem, so that the issue and problem can be dealt with in a quick and efficient manner. Another thing that we see is the lack of personal connection. It used to be that you could just walk down the hallway and you can have a conversation, or you could go into the break room and there'd be lots of people that you know and you can have these conversations. A lack of personal connection often leads to a lack of trust, and that can really erode the relationships that we have with people, and that can really have problems with then the way we communicate with people, and that ultimately can lead to harassment issues. So some of the best practices are to have team activities. If you're in a team, look online on the internet, and you can find some really interesting and good activities to do for your team. Have a buddy system or a mentor system where you just check in every once in a while with a coworker or subordinate and have a chat just to see what's up, kind of like a coffee talk or a water cooler talk, just to still maintain that relationship. And if you have the ability to have informal chat software like Teams is a good example, or Slack, Discord, there's all sorts of chat programs out there that is less informal than email, and you can have some conversations that makes it feel like it's the water cooler talk or the coffee talk that you would have in a workplace that's not virtual. And most importantly, if you feel that you are being harassed, even in a virtual workspace, you need to follow your employer's policy, and you need to make a complaint. It's really important. The policy still exists, and if you feel that harassment is occurring, you need to make that complaint. You want to make sure that your issues and problems are being addressed. And employers, if you're getting complaints from your subordinates, make sure that you're following your own policy. What does the policy say when you get a complaint of discrimination? What should you do? Make sure you're following it. The working at home, the COVID-19 situation where we're now socially distancing and we're working at home, doesn't mean that there aren't going to be complaints of harassment, and it doesn't mean that you don't have to do anything with those complaints. You still have to follow what your policies state and what the law mandates for compliance with federal regulations. So that's kind of the harassment aspect. It's still there and alive, and we want to make sure that we're keeping an eye on it as employers, and as employees, we want to make sure that we're aware of it and making sure that we're trying to keep the workplace respectful. But there are some things that COVID-19, or because it's a pandemic, that the CDC has made and said that this is now declared a pandemic. There are a few things that have changed with the ADA, which is the Americans with Disabilities Act. And the nice thing is most things haven't changed, but there is one big thing that has changed, and it's going to be what's called the direct threat defense. So let's first talk about reasonable accommodations. Reasonable accommodations, nothing has really changed with reasonable accommodations. We're going to talk about that in a bit. Direct threat, we're going to learn about what direct threat is and why suddenly it's something that you need to understand. I will say that if you've ever heard me talk about the ADA, when I start talking about direct threat, I immediately say, direct threat, if you're thinking about the direct threat defense, you should be talking to your general counsel, you should be talking to your legal team, because it really does get complicated and involved. And so it's kind of a big deal. And then we're also going to finish up with disability-related medical inquiries and medical exam, which relate directly to the direct threat. So first of all, reasonable accommodations, nothing really has changed with reasonable accommodations, okay? So a reasonable accommodation is a change in the work environment that allows an individual with a disability to have equal opportunity to either apply for a job, to perform a job's essential functions, really basically to enjoy any benefit of employment. Reasonable accommodation is the change that allows that to occur. And so employers must still accommodate applications, must still accommodate applicants and employees with a disability during a pandemic. Now, there may be new requests for accommodations, and you may find that, and that's fine. If an employee now requests an accommodation because of a disability, because maybe their workplace has changed or maybe some responsibilities and duties have changed, then that is still the process that you are going to go through, the reasonable accommodation process. You're still going to go through that process. Nothing has changed in that. The only thing that you might want to be aware of is because there may be some supply issues with if there's a reasonable accommodation that needs to be sourced and gotten from a place or bought from a place, there may be some supply issues where it may take longer for that to occur. But really, that's the only thing that we would take into account based on the COVID-19, the pandemic. Everything else is the same. The employee is still entitled to a quick, interactive process, and so that's what you need to make sure as an employer you're doing. And if you need an accommodation because of your disability, you still can request one. It's still something that you should be doing at that time. Okay. Now, direct threat. Now is where it kind of gets tricky. So the reason I'm even talking about direct threat is because based on the CDC, the COVID-19 pandemic meets the direct threat standard. Okay, and so what exactly is a direct threat? So a direct threat is a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated by a reasonable accommodation. Okay, and so that's an interesting thing to think about, because what it's actually saying is that the reason why we're either not able to provide a reasonable accommodation, or the reason why we're able to give a medical exam when we normally wouldn't be able to give a medical exam, is because of the direct threat standard. And because COVID-19 pandemic meets that standard, there may be some things that the employer can do that they would normally not be able to do. Now, the one thing I want you to make sure of is when you look at the standard of what COVID-19, some of the guidance from and the threat of COVID-19, make sure you're taking it from the CDC or a local public health official. It should not and it cannot just be based on your own thoughts or perceptions of what is, what COVID-19 is, what a pandemic is, or what you think a threat is. Because there are really very specific things that you have to consider legally when you're looking at a direct threat. One of those factors is the duration of the risk. Okay, and it has to be based on a specific factual information. It can't be subjective, right? So what's the duration of the risk? You have to look at the nature and severity of the potential harm, the likelihood that the potential harm will occur, and then the imminence of that potential harm. Okay, those are the factors that you would think about when you're thinking about the direct threat defense. Now, the reason why this even comes up is basically because of medical questions, medical related questions, and medical examinations. So just kind of refresh our memories here. Pre-offer, employers should not be asking any type of question or require any examinations that's going to elicit information about a disability. So if these are for applicants, if you haven't given the person a job yet, you should not be asking them questions about medical questions or anything that's going to get any kind of medical information. Post-offer, once you've offered that person a job, then you may ask questions or conduct examinations as long as you do it to everybody. So if you have a medical exam that all employees in that particular job need to go through before they start, then that's fine. That's okay. You can ask those medical questions. You can do medical exams. Importantly, if it's a current employee, okay, the only way you'd be able to, give a medical exam or ask questions that would elicit information, medical information, would be if it is job related and consistent with business necessity, or importantly, if you think that disability would pose a direct threat. And that's why we now are able to, or employers are able to ask those kinds of medical questions like getting somebody's temperature. That's a medical exam, right? You would not normally be able to do that, but because the CDC has said COVID-19 could be a direct threat because it's a pandemic, now you're able to ask those medical exams and have those people take those medical exams based on that specific information. Okay, so so I have gotten a few questions, and there are even more questions, but these are some of the questions that I get most often, and I've taken these directly from our website. So you're going to be able to find this exact information written in the exact way from our website. But I thought I'd just 3 questions that I get most often, the ones I want to talk about. So how much information may an employer request from an employee who calls in sick? Okay, so normally, as we know, asking medical information or asking questions that would elicit medical information for current employees, you would not be able to do that. But you can if you think that there may be a direct threat. So during a pandemic, ADA covered employers may ask employees if they are experiencing symptoms of the pandemic virus. For COVID-19, these symptoms include things like fever, chill, cough, shortness of breath, or a sore throat. And so make sure if you're getting that information, you still need to maintain that information in a separate confidential medical record, right? Because it's still medical information and you still need to keep it confidential. That has not changed, okay? The ability to ask those questions have changed because of the direct threat that it could cause, okay? So you can ask those types of questions. Another thing, when may an ADA covered employee take the body temperature of employees during the COVID-19 pandemic? Okay, so again, we already talked about this. Normally, you would not be able to do something like that. That's considered a medical examination. However, because the CDC has said that community spread of the COVID-19 is an issue and could be a direct threat, you can take some precautions, and that would be measuring the employee's body temperature. All right. Be aware, though, that there are other symptoms of COVID-19 other than body temperature. And so just because someone has a fever doesn't mean that they have COVID-19, okay? And so you want to make sure that you're checking not just the body temperature, but you're asking other questions to make sure, and these questions, right, are based on the medical information from the CDC or local or state authorities, so that you are getting a assessment of that individual that is not just based on your thoughts or stereotypes or perceptions, it's based on factual, subjective evidence, okay? And that is the key. And then lastly, this is the last question that I normally get, and it's a long one, but I did want to make sure that we reviewed it. The CDC identifies a number of medical conditions that might place individuals at higher risk for severe illness if they get COVID-19. As an employer knows that an employee has one of these conditions and is concerned that his health will be jeopardized upon returning to the workplace, but the employee has not requested an accommodation. How does the ADA apply to this situation? If this is something that you're thinking about, okay, I would highly recommend going to the EEOC's website because we list a whole bunch of really good information about this very thing. I'm going to read some of that right now. But the first thing that you want to remember if you're an employer is that if an employee hasn't requested an accommodation, the ADA doesn't mandate that you take any action, okay? So you don't want to assume that this person is disabled, right? You don't want to regard this person as disabled or has a disability. They haven't requested an accommodation, then you don't have to take action, okay? So if an employer is concerned about the employee's health about being jeopardized upon returning to work, the ADA does not allow that employer to exclude that employee or take any other adverse action solely because that employee has a disability that the CDC identifies as potentially placing them at a higher risk for severe illness if it gets COVID-19. Under the ADA, such action is not allowed unless that employee's disability poses a direct threat to the health that cannot be eliminated by a reasonable accommodation. And so you want to go through the reasonable accommodation process first. Okay, is there an accommodation that would allow this person to still be able to do the essential functions of their job? Okay, and because they have that disability. All right, you as an employee or employer are not going to be making any assumptions about that employee, and it's up to that employer to ask for those accommodations. So one thing to just to make sure that you're aware of is that this is not really anything different than that you would normally do when you're looking at a reasonable accommodation issue. Okay, the direct threat defense is there, but it's not something that is going to change too much the way you think about a reasonable accommodation and providing a reasonable accommodation to an individual that needs it. So one thing I did want to go over, because this is something that that has come up, is the wearing of protective equipment. So certainly an employee may require employees to wear personal protective equipment. And if you are an employer that does that, then think about, are there accommodations that a person may need? If you're requiring protective gowns to be worn in the workplace and a person is in a wheelchair, there may be an accommodation to have a specific gown made that covers that person and that wheelchair. If a person has a disability that does not allow them to wear latex gloves, okay, are there other types of gloves that that person can wear? You still need to look at reasonable accommodations if you're requiring a new aspect of that person's job, okay, if there's a new requirement for that person. So the main takeaways for employers, they should ask themselves a couple things. First, what is the CDC guidance? What does the CDC say about what the symptoms are, and what do they say about what should be done about those types of symptoms? What is a threat and what is not a threat? Okay. Then you have to look, is this person a direct threat? There may be an instance if someone's working at home and they are not interacting with other employees, they may not be a direct threat. And so there may not be any type of medical examination that you would give to that individual, right? Because they're not a direct threat, because they're not actually interacting with people, okay? And then even if they are, you have to look at, is there an accommodation that would lessen the threat of that individual that I can provide that would allow that person to do the essential functions of the job? Okay, so you have to go through that kind of thought process. What does the CDC say about coronavirus? Okay, is this person going to be a direct threat? And is there an accommodation that's going to allow this person not to be, for that threat to be diminished? Okay, and those are the things that you want to be thinking about with the COVID-19. Now, before I kind of hand this back, again, I do want to make sure that because this is such an ongoing and living process, the EEOC just put out new guidance on the coronavirus. So again, this is the best resource for you right now, www.eeoc.gov/coronavirus. And it's going to have lots and lots of information for both employers and employees. And chances are you're going to be able to get your questions answered just by looking at this website. It's really that comprehensive. If not, please reach out to me. My name again, Brian Shoemaker. I'm the Outreach and Education Coordinator. You can email me or you can give me a call. No problems there, and I will be able to direct either I'll be able to direct you to the proper place, or I'll be able to answer your questions at that time. So I am going to, I'm going to quick see, I don't know if there are any questions, Mackenzie, out there, but if not, I'm going to then hand it back over to Keisha.
Brian, I do see that there is a question, and
Okay.
if we'll just wait until the end, I have 2 more slides that I'd like to share, and we'll be ready for the Q&A. So I would just like to enlighten you guys on how to file a complaint. If you feel that you've been discriminated against, you can file a complaint with our agency. Complaints of discrimination in employment must be reported within 180 days of the alleged discriminatory action or whatever harm you feel that you have been subjected to. ICRC staff are here to assist you. Even though we are not open to walk-ins at this time, we are available by phone or by our website. So you can reach us in either, and I will give you the contact information in just a bit. And it appears that complaints against employers of 15 or more are considered dual filed with EEOC, meaning that we have joint jurisdiction and we do share responsibility in terms of making sure that those investigations are completed. And any resident or employee, you don't have to live within the state of Indiana in order to file a complaint here. If you're an employee here, then you can file here. And moving on to that contact information, we are at the Government Center. We are located at this address, and our website address is in.gov/ICRC. So I'd like to thank Brian for sharing so much information, so much helpful information, and helping us to understand what a direct threat is, and that's also a reflection of the fact that this is only a temporary answer to a temporary problem. Again, remember that pandemics are not permanent and that we will get through this, and hopefully a vaccine is on its way. So with that being said, we can go to the Q&A.
All right, thank you, Keisha, and thank you, Brian. We do have a couple questions. I'm going to go ahead and read off the first one. It is this one, Brian, you might be able to answer this. It is, what qualifies an employer as ADA covered?
Oh, a great question. If you have more than 15 employees, you'd be covered by the ADA. The only exception to that would be under the Age and Discrimination Act. So if you're to fall into that jurisdiction, you'd have 20 or more employees. But for the ADA, 15 or more employees, you'd be a covered employer.
All right, thank you. And then the second one is, if an employee has asthma and the CDC says it increases the risk of COVID, are we required to provide an accommodation such as work from home?
Again, so that's a great question. And if the employee has not asked for an accommodation, then you do not have to worry about whether or not you're going to accommodate that individual. If the individual does have that disability, asthma, and they ask for an accommodation, then you'd go through the accommodation process just like you would any other time. So, that's where we're, if they ask for one, okay, great, go through the accommodation process. Your thought as an employer should always be, how can I accommodate this individual? If they haven't asked, then you do not need to go through that accommodation process.
And Brian, I'd like to follow up with a question as well. This is my understanding that if someone has some type of disability that makes them more prone to some kind of adverse reaction to COVID, that the employer wouldn't be able to force that employee to not report to the site. Does that make sense?
Correct. Right. So it's not. So the employer is not making that health recommendation for the employee. Should not be acting as the doctor, right, and saying, okay, we think that you may be at risk, so we don't want you to come to our place of work. Okay. That is something that that an employer is not going to prevent an employee from coming to work just because they think that employee is more susceptible. It's different if that employee may have symptoms of COVID-19, and that's a different analysis. But if you just think that person may be more likely to get COVID-19, you're not making health decisions for your employee.
Okay, and we have another question. Both of you can answer this one. When should an employee file with the ICRC versus EEOC?
I would say definitely if an employer has less than 15 employees, that you would need to go through ICRC, because in that case, EEOC would not have jurisdiction. If the employer employs at least 15, then we should both have jurisdiction, and you can file in either place. But of course, I would prefer that you come to ICRC.
Yeah, and I don't have. I mean, that's exactly right. It doesn't matter to us where you file. My main goal would be just to recommend that if you feel that your rights are being violated, that you actually file. We know that there are many people that do not file in harassment complaints. 85% of people do not file harassment complaints that feel that they're being harassed. And so, the important thing is that you are in fact filing with somebody.
I don't think we have any more questions right now, but I did want to go ahead and mention again that this entire presentation is going to be uploaded onto our website. And again, that's in.gov/ICRC. And we should have it uploaded tomorrow morning at the latest, as well as all of the questions and answers are also going to be uploaded there as well. And I'd like to forward, if anyone has any other questions that they think of after the presentation ends, to go ahead and send those questions onto myself, and I will forward them onto either Brian or Keisha, who can answer the question accordingly. And again, I'll go back to our contact slide here and leave that up for anyone who would like that. Thank you everybody for joining, and have a great afternoon and great rest of your week.